Hi, this is Adam Stofsky with Briefly, and I'm here with Deliesha Brown for the next video in our legal information series with Inland Counties Legal Services, ICLS. Deliesha is an expert in the law of government benefits, which is a pretty complex and interesting area of law with a lot of implications for Inland County's clients. So I'm really thrilled to be here. Deliesha, how are you today?
I'm great, yeah, Adam. Thank you. How are you?
Yeah, good. Good. So the topic we're going to cover today is something called consultative exams in the world of benefits. So can you tell us, Deliesha, what is that? What does that mean? What is a consultative exam and why is it important?
It is very important. And consultative exams are scheduled by federal agencies. So you'll see them scheduled by the Social Security Administration or the Veterans Affairs Administration when they are determining whether someone is disabled or continues to be disabled. So what happens is you'll get a little letter in the mail that says, hey, you've been scheduled a consultative exam. Please go to this location, and they'll give a medical facility's name. And so what they do is they have Social Security Administration licensed or contracted rather doctors to assess you, whether that be for your mental disabilities, your physical disabilities. And from that, they take that report that is written by that doctor, physician, psychiatrist, psychologist, and determine whether you're disabled or not, or continue to be disabled or not.
Okay, so what this means is anytime you're applying for a disability benefit of some kind. So you mentioned veterans disability benefits, or I'm assuming things like, is it like SSI or Social Security disability benefits? This is essentially the exam you need to go through so an expert can tell whoever is providing the benefit, hey, this person actually is disabled. Is that right?
Absolutely. And it's not always guaranteed that they'll schedule someone a consultative exam. But what we say is if you are scheduled one, absolutely attend the appointment. Um, these physician psychologists may only do a medical observation for 5-10 minutes. It's not really long. Um, they're going to ask very personal questions. So we ask that you be open and honest during these examinations. Also, if you have physical disabilities, maybe you have a back injury, they're going to want to see how far you can bend, how long you can stand, if you have a walker. So these are the things we recommend. If you have a walker, take it with you. Don't leave it at home because you're having a good day that day and you feel like you don't need it. If you have a prescribed assistive device, walker, cane, wheelchair, bring it with you. Do not go there without it. They may bend you over, right, from hip down. If you can't do that by yourself, because generally they'll hold on to you and kind of see how far you can bend and stretch. You cannot do any physical position they're trying to put you in on your own. Do not allow them to put you in that position because generally what they'll say is you can do it.
Wait, what do you mean? So they'll if you say I can't do it, I'm not even going to try. They're going to take that to they're going to take that to mean you saying, well, I'm not doing it. So they're going to assume you can do it. Is that what you mean?
Let me clarify. If they're going to say bend over, sometimes they'll have you touch your toes, right? Stand up and bend over and touch your toes. You can't do that on your own because usually they're supporting you. They're touching your back, they're holding your hip and helping you bend over. If you cannot do it on your own, do tell them, I cannot do it. It is painful. Please do not put me in that position. Because if you do and you allow them to put you in that position, they're going to assume that you can do that position on your own.
Right. So the goal here isn't to like be at your best and show them what you can do. You actually want to ideally establish that you indeed have the disability you do have. So you need to be as upfront with them, give as realistic a picture of what your disability allows you and doesn't allow you to do.
Exactly. Be as open and honest as possible um, about your pain. We understand this is the first time you're meeting this physician and probably will be the last time you'll ever see them. So it may be uncomfortable talking to someone about all the things that you're going through. However, it is important that they have all the information available to them to make a proper assessment. So the more information that you provide to them, the better.
So I apply for benefits, and this exam is scheduled. Is the exam evaluating kind of the whole picture of all possible disabilities? Or are they looking for the disability that you set on your application? So, for example, if I say I have terrible post-traumatic stress disorder, I can't do certain things, or I am in a wheelchair and I have mobility disabilities. So, are they gonna just kind of examine you for that one thing, or are they gonna kind of take a broader picture and give you a full examination?
That's a great question. When it comes to physical disabilities, they're going to look at that particular condition. If you are in a wheelchair and you have some type of knee issue, they're going to look at your knee. They're going to do a point test, right? Can you extend your leg? Can you bend your leg? It's very specific when it comes to physical disabilities. It's far more broad with psychological disabilities because they will do generalized tests, something called Serial 7, right? Can you remember certain items within 5 minutes?
Also,
And then they'll
cognitive
ask
tests, kind
you,
of general cognitive tests.
right, general cognitive, right? You may go in saying, I have PTSD, but then through their assessment, they also say, well, this person seems like they're also depressed. And they had high anxiety during this exam. They were reclusive. So it's more generalized because I think mental health conditions kind of interweave with one another.
Interesting. So, okay. So you go in for the exam, and this person, the doctor, a nurse practitioner, a psychiatrist, whoever it is, right, examines you. Do they get the last word? Is this it? They say you don't have a disability and you don't get benefits, or are they more providing information for the agency to make a decision?
That's a great question. I think from our perspective, it feels like they have the final word. However, under the rules, no. They look at all your medical evidence. So that would be the assessment from the consultative exam, all your medical records that you provided, any medical statements from your provider, your psychologist, your specialist, orthopedic specialist. They'll look at the evidence as a whole and make a determination. However, the opinions that line up more with the medical evidence will be given more weight than the opinions of someone that doesn't align with the medical evidence. So that's kind of how that works.
So if you have like a long record of you've had three back surgeries and whatever, all these operations, and then the consultative examiner is essentially confirming that, oh yeah, this person has terrible back issues, versus if they say, actually, I examined them and they look fine. It's sort of you're going to be given extra weight if it's consistent with the existing medical record.
Absolutely. It would be given more weight if it's far more consistent with the external objective medical evidence.
If let's say I'm applying for benefits because I need them and I get this exam. Well, first of all, do I get access to the whatever the examiner writes up? Do I get to see it?
Eventually, if you go to hearing, you will be created a hearing file, and that examination is in the records.
Okay. That's actually related then I guess to my question. So what happens if I get denied benefits because the this consultative examiner says that my disability is not as bad as I said it was, or it's not doesn't exist? Do I have any recourse? Can I disagree and say no, that person's wrong?
Absolutely. There are many levels of appeal, especially if we're in the realm of Social Security Administration, those SSI benefits, SSDI benefits. If you apply and you're denied, then your first level of recourse or appeal, as we call it, is your request for reconsideration. It's generally someone else that didn't review your application the first time, reviewing all the evidence and determining whether that initial decision was correct. If you're denied at this step, it's highly likely, we see it all the time, even when there's an abundance of medical evidence supporting the finding of disability. There is a second level of appeal, which is the request for hearing. you go before an administrative law judge. It's still informal in the sense that it's not an actual big courtroom like you see on TV. It's just you, the judge, your authorized representative, if you have someone representing you, an expert. It could be a vocational expert who testifies what jobs are available according to the evidence that they see on what you can and cannot do. And sometimes a medical expert that's going to review the medical evidence for the judge and make a medical finding on whether they believe your conditions are severe. And if you have any witnesses, you can bring any witnesses. So that's that level of appeal. And then if you receive an unfavorable decision from the administrative law judge, you can appeal to the appeals council, which is just a written argument saying why the judge made a wrong decision in your case. And if you still are denied at that stage, you could file a writ of mandate in the federal court.
Wow. So there's a lot of appeals. That's interesting.
Yeah,
Can you do this without a lawyer if you need to? Like at what levels can you do it without a lawyer?
all the way, every level. You're not required to have a attorney or paralegal, or even your friend can be your authorized representative if you want. You don't have to be an attorney to represent someone because it's an administrative hearing. However, we recommend that you do from the outset have an attorney or paralegal working under the direction of an attorney to represent you, because we are familiar with the process. We understand what is needed to prove your disability. We can guide you in, say, the consultative exam process, what to expect, what you should do, what you should avoid doing. Like, don't miss your consultative exam, right? Some people are like, well, I didn't feel good that day, so I just didn't go, but it can be looked upon as a negative for you, right? So having someone kind of guide you through the process and help you understand what's going on is extremely helpful and renders better results.
Okay, my last question is how can Inland County's legal services help folks who have an exam coming up or who are applying for disability benefits?
Absolutely. If you feel that you could do it on your own, but you just want some counseling advice, you can reach out to us. We'd be happy to explain the process, go over the facts, what to expect. We can look at the notice to see what type of exam you were scheduled, because say you have mental disabilities and physical disabilities, doesn't necessarily mean you're going to be seen for both. They may only schedule you a physical examination or a mental examination. So we'd be happy to discuss that process with you and prepare you. Even if you're going to hearing, you want to represent yourself, we'd be happy to provide you counseling advice and prepare you for hearing and what to expect. We also represent and act on behalf of individuals applying for benefits. You can reach out to us. We'd be happy to review your medical records, determine if you meet the disability requirements, and determine whether we can represent you.
Great. Well, Deliesha, thank you so much.
Absolutely. You're welcome.
All right, take care.